Do you think living outside the United States means the IRS can't touch you? It doesn't. In fact, millions of American expats are sitting on years of unfiled FBARs right now, and they have no idea the penalties can wipe out their savings and wreck their lives. Not because they hid money, because nobody told them they had to file in the first place. I'm attorney Chad Silver, founder of Silver Tax Group. We work with expats, dual citizens, and U.S. persons living abroad who are dealing with delinquent FBAR filings and offshore compliance issues. And today, I want to walk you through exactly what expats get wrong and how to fix it before the IRS shows up first. We're going to cover 4 things. Section 1, who actually has to file. Section 2, the mistakes expats make that turn a simple paperwork issue into a penalty nightmare. Section 3, what those penalties look like in real numbers. And Section 4, the one program that can fix this, but only if you act before the IRS does. Section 1, who has to file FBAR? If you are a U.S. person, a U.S. citizen, a green card holder, or someone who meets the IRS substantial presence test, and you have foreign financial accounts that exceeded $10,000 in combined value at any point during the year, you are required to file FinCEN Form 114. That's the FBAR. And here's what catches expats off guard every single time. The United States taxes based on citizenship, not residency. Where you live does not change your FBAR obligation, not even a little. I spoke with a client, we'll call her Sarah, a U.S. citizen who moved to Switzerland for work 15 years ago. She had a local checking account and a retirement fund she'd been building for years. She never filed once because her local Swiss accountant never mentioned it. By the time she called us, she had 15 years of unfiled FBARs and a very serious exposure problem. That is more common than you think. Section 2, the mistakes expats make that turn a paperwork issue into a penalty disaster. Mistake number 1, assuming someone else handled it. Most expats use a local accountant in their country of residence. That accountant knows local tax law. They don't know U.S. tax law. They filed your German taxes, your Australian taxes, great. They did not file your FBAR, and you assumed it was covered. It wasn't. Mistake number 2, forgetting an account. The $10,000 threshold applies to the aggregate value of all your foreign accounts combined. Checking, savings, brokerage, all of it. Miss one account, and your filing is wrong. Mistake number 3, not knowing foreign retirement accounts count. A UK ISA, a Canadian RRSP, a foreign pension fund, many of these trigger FBAR requirements. This one surprises people every single week. The bottom line on Section 2, if you're an expat and you've never had a U.S. tax attorney review your FBAR situation, you are guessing. And guessing with the IRS is not a strategy. If any of this sounds familiar, call us at 855-900-1040 or visit silvertaxgroup.com. We offer a confidential review, no obligation, and we'll tell you exactly what you're looking at. Section 3, what the penalties actually look like. For non-willful FBAR violations, meaning you didn't know, honest mistake, the penalty can be up to $10,000 per account per year. 3 accounts, 5 years. That's up to $150,000. For willful violations, meaning the IRS determines you knew and chose not to file the penalty jumps to the greater of $100,000 or 50% of the account balance per year. A retired couple I'll call David and Linda, U.S. citizens living in New Zealand, they had accounts they had held for years. They were not hiding money. They had no idea they needed to file. By the time the penalties were calculated, they were looking at $3.6 million. That is not a typo. Here's what makes this worse. The longer these filings go uncorrected, the easier it is for the IRS to build a willfulness case against you, even if you never intended to hide anything. The IRS uses your 1040 responses to build their evidence. Zero intent is not zero risk. Section 4, what you can actually do right now. There is a program designed specifically for expats in this situation. It's called the Streamlined Foreign Offshore Procedure. If you qualify, it lets you come into compliance for the past 3 years of returns and 6 years of FBARs with a significantly reduced penalty, in many cases, zero penalty. But, and this is critical, the program is only available to you if the IRS has not already started looking. The moment you're under audit or investigation, that door closes permanently. Timing is everything. At Silver Tax Group, we evaluate whether you qualify, we build your compliance strategy, we implement it, and we'll defend it if necessary before the IRS. No guessing, no fear. Just strong legal tax firepower on your side. Don't wait until the IRS comes knocking at your door. Call us at 855-900-1040 or visit silvertaxgroup.com for a confidential review today. We'll tell you where you stand and exactly how to fix it. I'm tax attorney Chad Silver. If this video helped you, click like below and subscribe. We put out content like this every week. I'll see you in the next one.